Good afternoon. Attorney Protective would like to welcome you to today's webinar, What Lies Beneath, Identifying Potential Legal Malpractice Exposure. Please reference your materials for information about today's speakers, Seth Laver and Matt Marrone. With that, I would like to introduce your first speaker, Seth.
Thanks, Kate, and thank you, Attorney Pro. Matt and I always enjoy this presentation. I can't believe it, but Matt and I were just talking about this. I think it's our 5th year giving this to this audience, so thank you, and thank you for joining us. We hope that this is an hour well spent. We think it will be. Matt and I are going to cover some traps facing attorneys. The title's What Lies Beneath. Risks are hidden, but often aren't totally unexpected if you know where to look. The truth is it's really impossible to instruct everyone here how to prevent malpractice claims. You can't prevent them, but you can help to avoid them. There's so many of you here, meaning different practice areas. There's different variables and jurisdictions, countless personalities. So again, there's just too much to prevent all claims, but there are some common themes that may resonate with you, and that's our goal. Let's start with today's agenda and an overview of what we're going to be talking about. As we've done in years past, we're going to throw some numbers at you, which prove still to this day that claims against attorneys are on the rise, perhaps even more so due to COVID, unfortunately. Next, we'll cover who are the typical plaintiffs and what the liability theories are. We'll discuss the beginning and end of an attorney-client relationship and some traps along the way. Of course, it's impossible to discuss malpractice without covering conflicts, so we'll hit that. We'll talk about the problem client, and then we'll conclude with some takeaways. And then finally, assuming we have enough time, we'll work to address some of your questions. Okay, for you fact checkers out there, we've obtained some data from insurers and consultants who compile legal malpractice trends every few years. The update that you see on your screen is the first post-COVID set of data. And spoiler alert, this is mostly bad news. The number of claims and severity of those claims is rising. Reportedly, malpractice claim frequency hit an all-time high in 2019 and has leveled off just a bit. More suits was the trend since 2011, finally tapered somewhat over the past few years. And while the number of claims is tapering, the bad news is that exposure and cost of defending suits is higher than it's ever been, meaning mistakes are more expensive today than in the past. What's interesting is we're learning that many claims settle before even hitting suit. So the numbers that are reflected on your screen may not even include those allegations that don't hit the docket. And again, it's fair to expect an uptick in claims rising out of COVID. So why are we hitting you with all bad news? As we see it, this data is really helpful. It helps to address why these numbers are rising. And if we can understand the why, it will help to reduce those risks in your practice. So we won't address every topic on this list, but just a couple highlights. First, there's more lawyers. There's just more lawyers today than ever in history, about 1.5 million lawyers in 2023, particularly, by the way, in New York, Massachusetts, and Maryland. On average, there's about 200,000 more lawyers every year since 2008 in the United States. And those numbers are starting to tail off a bit. Not only are there more attorneys, but attorneys are living longer. We're retiring later. What does that mean? It means there's just more lawyers to sue. Not only that, but with all of these attorneys, there's more competition. And while competition can be a positive, it can drive us to be our best self, there's downsides. There's more reason to perhaps overpromise or overextend to keep or secure a client, more reason to set unrealistic expectations, also more reason to dabble outside your comfort zone. And for those that don't know, dabbling is when we take on work that we just don't know how to perform. And it's a terrific way to be sued. Next, you'll see insurance. Our carriers know that claims and expenses are rising, and brokers know these numbers too. So many attorneys carry more insurance. And of course, that's an important risk management tool, but it's also a larger target for plaintiffs to seek. Matt, what did I miss?
Thanks, Seth. Hi, everybody. It's Matt Marrone. Thanks. I'll echo the Seth's remarks. Thanks again for joining us. I know we've got quite a few people here. For the people who have joined us in the past, you're going to see some stuff some of this is going to be repetitive, but always worth mentioning, and we'll try to hit some new stuff for you. And to pick up on that issue, I'll piggyback on what Seth said. He mentioned that that claims are on the rise. In part due to COVID. I'll offer my sort of observation on that. I don't think that we're not seeing claims that are related to COVID, so to speak. What we're seeing, and I wish we had more current data. I'd love to see the data for 2023, which of course is not available yet. But anecdotally, talking to our colleagues around the country, lawyers and the insurance carriers that we work with, everybody is swamped this year. I mean, the amount of claims that are coming in this year and the amount of work that we're all getting is just, it's so much greater than it was the last couple of years. And I think that we can almost call that a COVID bump, so to speak, where things slowed down, obviously in 2020, even in 21, started to pick up last year. But I think what we're seeing toward the end of last year and this year is just more claims coming in. People are consulting with lawyers again and trying to right how they've been wronged, so to speak. And so this year, I expect the amount of claims to be higher than it was in the last couple of years, and sort of part of that, So I mean, legal malpractice, it's become kind of a niche or a specialty that lawyers have grown into and continue to grow into. Increasingly, what we're seeing is where somebody's been involved in a failed deal or a failed transaction or didn't get the result that they expected. Those folks increasingly are getting referred to lawyers who are willing and able to take a shot at representing that client in a legal malpractice case against the first lawyer that represented them, especially if the potential damages are high enough. If it's a lucrative enough case, we're seeing more and more lawyers willing to file those. Again, talking about COVID or post-COVID, all the studies are showing, and we've gone to many seminars that show this, juries are awarding bigger and bigger verdicts coming out of COVID. That's just a fact. People are, in general, less tolerant, less patient, more willing to blame people, angry, whatever the drivers are. But across the country, you often hear this term nuclear verdicts, which the firm Tyson and Mendes, who we're friendly with, has actually trademarked that term. But they're nuclear verdicts. These verdicts that are just getting bigger and bigger. And legal malpractice cases have not escaped that trend. We read about new case filings all the time, settlements, verdicts every day. And the claims are becoming the plaintiff's lawyers are becoming more sophisticated. They're putting together more sophisticated theories, and they're leading to bigger numbers. And that is, like Seth said, we've been doing this now for about 5 or 6 years, and we've watched this continue to happen over the last 5 or 6 years, and in particular over the last few years. So those are the I guess. It dovetails into, I guess, higher consumer expectations that we're looking at there. Also more insurance, because plaintiffs' lawyers know that there's insurance there, and especially if they're large firms, know that there's towers of insurance, with millions of dollars of insurance that's available. And, it's increasingly becoming a business. So that's how I would, I guess what I would offer in terms of the bad news on this slide. So I'll kick it back to you, Seth.
Yeah, thanks, Matt. And I think you make a good point about how the plaintiff's bar seems much more willing to accept these cases when I was a baby lawyer, there were few and far between with the idea, whether it was karma or whatnot. There were attorneys that were unwilling to sue attorneys. That is clearly not the case. All right, let's dig into these numbers a bit more on the next slide. We're going to take a look at what types of attorneys are most likely to be sued. And as it's been every year since about 2013, trust and estate attorneys are statistically the most likely attorney to be sued. In fact, the most vulnerable is the solo trust and estates attorney. And we believe we know why, and that's because these attorneys handle personal, sensitive matters. There's a level of trust and kind of hand-holding and vulnerability there that the client in that instance is more willing or more likely to feel dissatisfied or let down. It's often very emotional. There's all sorts of conflict issues in trust and estates matters, and we'll talk about conflicts later. And due to the beneficiaries, the potential pool of plaintiffs who could sue a trust and estate attorney is higher than perhaps other attorneys. What else is listed here? We could spend time on each item on the list, but a word about collection. And we, as hard as we tried, we couldn't find specific data on this point, but it seems in my practice, and likely Matt's as well, anytime one of my clients seeks to collect unpaid fees, they get sued. Unfortunately, collection claims are very risky. They often result in a counterclaim for malpractice. So a word of caution to simply be wary of collection suits. And another item on this list, you'll see it on the bottom there, is insurance defense. This is a new data point. Claims against us, insurance defense attorneys, has jumped by almost 20%. And these claims are tricky and vary by state. The tripartite relationship makes these claims complex because there's an issue of standing, who owns the claim. So the takeaway for practitioners in the defense bar, insurance defense counsel, is to practice what you preach. It's one thing to give risk management presentations like the one that Matt and I are doing right now, but it's another thing to actually follow your own advice. Matt, what do you
Seth,
think?
your observation on the insurance defense piece there, and again, that's the number from 2021. I'd love to see the numbers for the years after that. But if you look at those numbers, it's zero for every year before that. And what's that mean? So just to be clear here, when insurance defense lawyers are being sued, they're being sued by the insurance carrier. So what's happening, again, this is just, it's sort of like risk transfer. So, you know, the defense lawyers are hired by the insurance company to defend somebody, and a bad result happens for whatever reason, you know, a big verdict at trial or something, and the insurance carrier that retained the defense lawyer is turning around and suing the defense firm now, saying that, you know, so they're basically trying to mitigate their losses, right? They're trying to transfer the loss to them over to the lawyer. I mean, that was, you know, as the stats show a few years ago, that was unheard of. That never happened. And now it's happening. So this is to the point again about how insurance is kind of driving this. Well, there it is. You know, it's insurance carriers essentially fighting each other for who's going to be responsible for a loss. One note about this survey, which again done by Ames and Goff, they're awesome. The fact they do this, they're a broker. So I believe this is a survey of insurers of large law firms. So the numbers that we're seeing here and the areas of practice that we're seeing here, I think, these are malpractice claims that large law firms are dealing with, which might be a little bit different from a solo practitioner or a small firm like under 5 lawyers. And I suspect we have quite a few of those on the line today. What I would say is, you know, for instance, there, like the fourth category, corporate securities, you know, a solo or a small firm is probably less likely to get hit with a claim related to corporate securities or maybe even taxation, where you have large firms dealing with this. But to Seth's point, the top 2 on that list, transactional and trust and estates, that's going to cross every size of firm. I mean, we represent a lot of small firms, and these numbers are consistent with the claims that we're seeing and that we're defending. I would add to what Seth said about trust and estates being a huge one. I mean, again, if we go back years ago, the biggest one would have been personal injury plaintiff. Now it's 5th on the list. But trust and estates, you know, why are claims happening there? Well, the baby boomers are aging. they're to die. They're starting to transfer wealth. They're the largest generation in history. And so we're seeing sort of the largest transfer of wealth in history. And what's going to happen there? Well, people are going to be upset with what they're getting or what they're not getting. And we're seeing trust and estates lawyers get roped into those disputes. And this is going to keep happening. I mean, the boomers are, I think the youngest boomers are maybe in their early mid 70s right now. We've got, or the oldest ones, I should say, I think the oldest ones are there. So we're going to see this for a while. And here's something that I've noticed too, that I fear it's going to become a vicious cycle. And here's why. The demand for trust and estate services, trust and estate attorney services is only going to increase as these people age and as we're talking about, what's needed to transfer the wealth. There aren't that many lawyers who do this. So the demand is going to exceed what I think is the supply of those services. And that's going to lead to, I think, a lot of people dabbling a little bit, maybe going outside of their comfort zone because their clients are saying, I need a will, or I need to do this, need to do that. And even if it's not something you typically do, you might want to help your client and who needs this help. And if you're straying outside of what you normally do, especially into the trust and estates realm, that's very dangerous. And I think it's going to lead to more claims. I think it's going to lead to more dabbling, and it's going to lead to more claims, unfortunately. And that's just because of kind of what the market, so to speak, market conditions are dictating. So it's and the trust and estates malpractice claims, they can take so many different complexions. I mean, we could spend a full day talking about trust and estates malpractice claims. They're not straightforward. They're not cut and dried, and they can be nasty. So. Back to you, Seth.
Okay. Thanks, Matt. So this is our. We're going to talk a bit about the types of claims that we're seeing. As it's been, for as long as I can remember, conflicts of interest are the highest reported type of claim facing an attorney by 2 to 3 times, and the risks are growing as firms are expanding through mergers, and we'll talk about mergers in a bit. Reportedly, firms just don't have competent conflict safeguards in place, so conflicts are still a problem. And look what else is here: general negligence, failure to file timely. These are preventable, but others can be the result of just bad luck. So again, as I suggested earlier, knowing the type of risks you're facing may help you to avoid them in your practice. Next, Matt, you're going to cover our last slide where we dig into some numbers.
Yeah, I think real quick on this slide here, what I would say again is that again, this is a survey of large firms. This is of insurers of large firms. And so I think we're going to see conflicts of interest as a much bigger driver of malpractice claims in large law firms where they're almost used as a hammer to show that the firm is favoring one client over another. It sort of gets juries angry, selling out one client in favor of another. We do see them arise in the claims involving smaller firms as well, but I would say that actually number 2 there, general negligence, is probably the one that if we had to put them in a category, one that I see the most, and that's just Monday morning quarterbacking. General negligence, that somebody again is upset after the fact, feels like the lawyer should have given different advice, should have advised the client to do something differently, and that's what they're suing for. That's probably, if I'm looking at this list and the one that I see the most, that would be the one. And that's, again, just the expectations and trying to essentially hold the lawyer to the standard of being a guarantor of an outcome, which of course is not the law, but that doesn't seem to stop them. So, okay, so so the next slide. I mean, I guess this is coming from the same survey. This shows the different rate categories that defense lawyers are being paid. Makes me realize we need to adjust our rates, Seth. I think looking at this, I'm joking, sort of, but where this does come in, actually, though, for defense costs, and we'll touch on it later, is how your malpractice policy responds to a claim and what your limit is, and whether the defense costs actually erode your limit of liability. Because if the claims get really expensive to defend, that can actually reduce your malpractice limit that'll ultimately be there to protect you. So that's sort of the comments I would have on that slide, and then I think we get into the next one here with the pumpkin, right?
Yep, that's right. Thanks, Matt. So we know the claims are rising. We know the cost of defense are rising. We know exposure is rising. So obviously this is enough to make attorneys wary. And it certainly has made carriers wary. And that leads us to what goes bump in the night. This is a new response to that carrier survey that we've been talking about for the past 20 minutes or so. For the first time, carriers were asked, what keeps you up in the night? And there were three real categories that the responses fell into: lateral hires, COVID, and silent cyber. And we're gonna hit on each of those. So in terms of lateral hires and attorney migration, I find this stuff fascinating. But lateral hiring is up 45% since 2019. And again, hold on to your seat, but reportedly about a half of those moves fail. And 35% of all malpractice claims involve a lateral hire, which is just astonishing to me. That means it's about 8 times larger than the risk for an incumbent attorney. Now, why? I don't know. Is it that they're not complying with internal risk management tools? There's less due diligence? What leads to these claims? Matt, I know you wanted to make a point about kind of the landscape of our industry.
Yeah, no, it's interesting that I didn't realize that, but it sort of makes, I guess it makes some sense. I mean, the again, just in talking to colleagues around the country for what we do, and I mean, we all, like, one thing that's clear to me is, I mean, this year in particular, and I guess even last year too, everyone is really busy. We're all really busy, and we all need more help. We all need more, or at least a lot of the people I talk to all need more help, need more lawyers. And frankly, the pool of lawyers, I know, Seth, you said that there's more lawyers than ever, but it feels like, in post-COVID, a lot of lawyers exited the industry. People retired early. People switched to different careers, left the practice of law, maybe went in-house, maybe decided to do something totally different. We all hear about the great resignation that crosses industries. It's certainly, from my observation and the observation of lots and lots of people I've talked to, it certainly has impacted the legal industry as well. And so, we all need more good lawyers, and there aren't as many around anymore. And that's a trend that I kind of think is going to continue, which is a little concerning for everybody. That there's still going to be, sort of back to the trust and estates example, there's going to be an increased demand for the work and less people to do it. And that puts more strains on everybody, and just sort of, could end up being a problem. And I think this stat set that you cited kind of ties into that.
It does, yeah. And so that's the first nightmare. The second is COVID. Surprise to no one. Carriers are reporting nightmares about COVID-related claims. And look, many of us are probably sick of hearing about COVID, but the impact on all claims, including legal malpractice claims, is real. We know, looking backward, that after the '08 recession, there was a huge surge in legal malpractice claims. Businesses failed, clients sought other means to recover. Clients were perhaps more willing to file suit than they would be in a better environment. And against that backdrop, experts predict that COVID will spark a similar spike in claims, and that's concerning to carriers. What kind of risks did COVID, the swap to a COVID environment present? There was new rules in place, new deadlines. We need to update firm documentation and handbooks, effectively communicate with clients and colleagues in a remote environment, perhaps. Need to monitor technology in a different way and stay on top of developments, because ignorance just isn't an excuse. And then take a moment and think about another COVID-related risk of data security. Be mindful of the real risk of cyber and even physical crime during COVID if you're not in the office. Fraudsters have utilized COVID to gain access to confidential materials and data, which leads nicely into silent cyber, which Matt, you're up.
Yeah, thanks. So again, we could spend an entire day or multiple days on cyber stuff, and Seth and I are not cyber experts, but I want to take a few minutes here to talk about how we've seen some of these issues creep into what we're handling and try to give everybody here a few quick pointers. So I'm going to hit you with, I think, a lot here in the next few minutes. Hopefully I can do it effectively. And so let's talk about, I want to talk about what we call business email compromise, first of all. And here's a common situation I'll use to set the stage. And this is something we see in our cases. You're representing a buyer of a piece of real estate, let's say. You've been emailing with your client as the closing date is approaching. Meanwhile, unbeknownst to you, a bad guy, they call them threat actors in the industry, has tapped into your email system without you knowing, and they're monitoring your email traffic. This happens. Maybe it happened because maybe you or someone else in your firm clicked on a link in another email months earlier thinking it was valid, but in reality it gave that person a portal into your system, and you didn't even know it. So the closing date's a few days away, and your client needs to wire funds either to you or to a settlement agent. You email wiring instructions to your client. The threat actor intercepts that email and crafts a different email that looks like it's coming from you, from your actual email address within the context of your system, and it has different wiring instructions that get sent to your client. Your client wires, let's say, $500,000 to the bad guy. Once everyone realizes it, the client's now looking at you to make it right. We've seen a version of that scenario in a whole bunch of claims within the last couple of years, and lawyers end up getting sued for it. So, is that a malpractice claim per se? Well, that's debatable. But there's a few pointers I want to give you to keep in mind. First, if you don't already have multi-factor authentication, also called MFA, on your network, or if you don't even know what that is, talk to your IT person about it. As I understand from industry experts, MFA is the single most effective and easiest way to prevent these threat actors from hacking into your system. And the example is that, like, for instance, when I sign into my system at work, or when Seth does, it sends a code to my cell phone, and I need to enter that code on my computer in order to sign in. It's a way to ensure it's actually me signing in and not somebody else. So learn about MFA and how you can implement that in your computer system, in your email system in particular. Second, if you're sending wiring instructions to clients, if this is part of your practice, tell them they first need to call the place where the wire is being sent before wiring the money to confirm they're actually wiring it to the right place. Don't call a number that's in the email, because that could be fake. You can look up look the place up on the web, call a trusted number to ensure that the instructions are correct. Double check. Tell the client to double check that they're sending that they're wiring money to the right place. And relatedly, if you're holding money and then you're wiring client funds, you need to do the same. And then finally, look at your malpractice policy to find out if it will cover this type of situation. Ask your broker or carrier the same thing, because this whole area, this whole idea of cyber claims, cyber coverage, it's still a bit of a frontier, and based on what I can see, insurance carriers are still working through how or whether they're going to cover this kind of a situation. So, ask the questions: does this fall within your primary malpractice limit? Is there a cyber endorsement of coverage on your policy that maybe affords a lower limit? Is the carrier going to exclude this sort of a loss? Is there another policy you need? Consider a standalone cyber policy, but even then, ask the same questions, because even cyber policies can differ dramatically on things that they cover. So do everything you can to, if you're handling, again, this really applies to those of you who are handling matters where you're either sending wiring instructions or wiring money. Do everything you can to make sure that you're covered for this sort of a loss. And, so where do we see these issues arise? Going back to the other slide about where we see the claims, in transactional matters primarily. And so hopefully, so think about, ask people about MFA, multi-factor authentication, if you don't have it. Make sure that that people are sending wire money to the right places, and check your policy to see if you're covered for that kind of a thing, because we're seeing these claims a lot against lawyers. So, okay, hopefully that was helpful. Are we on to the next slide now, Seth?
You sure are. You're on a roll. Keep going.
Oh, me? Okay. So, all right. Legal malpractice exposure. All right. So, So, traditionally, and this kind of gets into some things we've covered these things in the past, but we'll hit them here again, and it's worth. This is important stuff. So, traditionally, and even in some states, privity is the rule of the day. Attorney represents client, and there's the attorney-client relationship, and therefore, that's who you owe your responsibility to, that's who you owe your duty to, that's who you're exposed to if you end up messing up. Increasingly over the years, and again, it really is state dependent on how liberal, so to speak, your on this topic your state may be, but courts are more willing to allow people from outside of that attorney-client relationship to sue you as a lawyer, arguing that you owed some sort of a duty to them, and that can be because under a third-party beneficiary theory. It can also be that if you happen to say something, misrepresent something to somebody outside of the relationship that they then relied upon. Another example here is beneficiaries of a will. So and we see claims from all of these people, and it's where, as we'll get to it a little bit, it's where engagement and disengagement letters can come into play and help reduce this, because what you want to do is you're going to have enough, as we're seeing here. There's enough scary stuff out there that you might face from your own client. So, you want to do what you can to reduce that exposure from outside of the attorney-client relationship. And that's, so we get to the next slide here, liability theories. This is, generally speaking, the malpractice case, historically, it's rooted either in negligence concepts or breach of contract. If you've got an engagement letter, there's a contractual relationship there. A lot of states have, for instance, in Pennsylvania, we have a different, which is one of the states where we practice, we have a different statute of limitations for negligence and breach of contract. Negligence is 2 years, breach of contract is 4 years, which can kind of make things weird for a malpractice claim. Most states where that's the same situation what they've done is they've basically said whether you're going to couch this claim as one in negligence or contract, we're going to give it the same statute of limitations, which I think is the right way to do. And again, for instance, in Pennsylvania at least, I wish they would do that here. So misrepresentation, again, that's a claim that you might face from somebody outside of the attorney-client relationship. Breach of fiduciary duty. Let's say, just as an example, if you're handling an estate administration, you are representing the estate, but you still have fiduciary duties, to the beneficiaries to administer that estate correctly, to marshal the assets correctly, to handle tax matters and to file tax returns on time. So, those aren't necessarily malpractice claims, but they're breach of fiduciary duty claims that you might face. And then fraud and conspiracy. We still we see it less and less, but we still see it. Usually, people who are starting that just don't really know what it's one of those, you see one of those complaints where kind of the entire kitchen sink is thrown in and there's 24 different causes of action, and they're throwing in fraud and conspiracy, which really is unwarranted. But so those are the different theories. I still on, Seth, here for the next one, or?
Nope. You grab a coffee.
Okay.
All right. Next, we're going to talk about how to evaluate attorney conduct, and there's somewhat of a hierarchy here. We look to several standards, and this is theoretically in order. We'll start with the standard of care in each jurisdiction, which usually is what would a reasonable attorney in the area have done in this scenario. So that's really the first place you'd want to look. The next, we have guidance from the rules of professional conduct. The RPCs may be different in each jurisdiction, and there's also the model rules. But just remember that these rules are a guide. A breach of the rules of professional conduct does not automatically mean a breach of the standard of care, but it's likely evidence of negligent conduct. And then you can look to case law, applying law to attorneys. If that's not helpful, then you go to the law applying to other professionals, accountants and whatnot. Finally, look to state regulations to evaluate the attorney standards of care. In terms of the hierarchy, the standards hold the most water, followed by case law, and finally state regs. Next, we'll hit the slide that's on your screen, and Matt's going to talk about the lifespan of the attorney-client relationship.
Okay. All right. So that's going to, right. I think it's then generally going to tie into, engagement and disengagement. So, and by the way, I want to, while Seth's talking, I'm kind of looking at we see some of the questions you all are putting in the box here. There's a ton of really good ones. I hope you all understand that we're not going to be able to address every single one of these. We're going to try to address some at the end, but I want to, for the people who are, I could go down a rabbit hole here pretty easily, which we were told not to look at these questions because if I look at them, I want to answer them all. So, but there's really a lot of great questions here. So thanks for paying attention so far and for thinking these issues through. So, attorney-client relationship, historically, it would, in the ideal world, it's started when an engagement letter is signed. Attorney or client consults attorney about a potential matter. Attorney agrees to represent client in that matter. An engagement letter is signed. It's clear. It's neat, and everybody has clear understandings of it, and then off you go. But what we find is that it's very easy for that to become blurry. If, let's say, a client comes and consults with you about a potential matter, you're not quite sure about what you're going to do about it. You think on it for a while, maybe in your own mind, maybe you forget about it. Maybe the client, kind of forgets about it, and and nobody does anything, and before you know it, oops, a statute of limitations is passed. And, you can say, well, I never agreed to represent you on this, so this isn't my fault. But from the client's perspective, they might say, well, I thought you were representing me on this. I thought you were handling this, So that's how, if we kind of contrast, the different ends of the spectrum where we can really look at it and know exactly when it started and know exactly when it ends by sending, a letter that terminates the engagement at the end, instead of leaving it open-ended at the front end and at the back end. And that's where I think, we're getting into the part here that is, if you hear, well, we're hitting you with a lot of good stuff here, but the engagement letters, disengagement letters, that kind of stuff, super important. And that's what we're getting into here. So on the next slide here, we're talking about different aspects of the attorney-client relationship. It's interesting. So we've touched on these first 2 points in the past, and I get why Attorney Pro has put some slides in here, because it is sort of interesting. But I'll say this, Seth and I talked about it before the presentation. Casual legal advice and online advice, I've never seen a malpractice claim that has come out of either of those two topics. I'm not saying that they aren't out there. I'm not saying that those aren't topics that you should pay attention to and be careful of. But from having defended hundreds, if not thousands, of legal malpractice claims myself and many more with Seth and others in our firm, I've never seen a malpractice claim come out of either of those first two topics. So, be careful, I guess. Be careful about having conversations at cocktail parties about somebody who's got, some legal issues. Be careful with it, but I would say you don't need to you don't need to be hyper aware of that. And I guess if we look at the next slide here, talk about casual legal advice. I mean, I would agree with the first point that it is legal advice, but I think most people, especially if you're being careful about it and you're just having a conversation with somebody, make it clear, I'd be happy to talk to you about this further. If you want to really, consider this, I'd be happy to talk to you about it further instead of just having this conversation. Don't offer a second opinion if already represented by counsel. I mean, that's I would agree with that. That's a little dangerous, but that, and then the next slide. I know we're moving fast here. It's we're about a quarter till 2. Online advice. I mean, I think most people know that if you're putting something out there, write it in general terms, provide a disclaimer. I have not, again, we haven't seen any claims that have resulted from this. I wonder if Attorney Pro has, actually. But that's, what the slide says there. Those are best practices, and I would say that you should listen to those. So, and then
all right, thanks, Matt. I can okay. Chime in at this point. Good. Sorry to speak over you, but the point is generally that it seems straightforward enough, but defining the beginning and end of a relationship is often problematic. And no one Foldham refers to. We've spoken about confusing the beginning of a relationship, but how about the end of it? And that's where disengagement letters can come in. A disengagement letter is a perfect tool to define the end of the relationship. The case could be over, transaction could be over, or there's a difference of opinion with the client. In that case, disengage, and the letter must be clear. What if the client stops cooperating or stops communicating? Time to disengage. Now, there are ethical considerations to disengagement. We need to ensure that disengagement doesn't unfairly impact the client. You'll need to check the local rules, but please add to your risk management toolkit a disengagement letter. And I believe in the upcoming slide we have a template to work from. Along those lines, you see the second bullet point is declination letters or non-engagement letter. These are a must. You need to ensure the potential client knows that they're not an actual client. And Matt's right. If you're in an Uber and you're casually providing, if you could see me, I'm giving air quotes, legal advice, I don't know that you necessarily need a declination letter there, but sometimes you need to make clear that you are not their lawyer. You are not accepting the engagement. Make clear that they cannot rely upon you. There are unreasonable folks out there that may misconstrue a casual conversation, or if they're sitting at your desk, for sure. So whether it's a non-client or a former client or an existing client, declination can confirm that you will not perform additional services for the client. And this is a perfect way to help define the scope of the engagement. Now, this isn't necessarily huge for the defense bar, but it's still a concern for all attorneys. All right. So speaking of the scope of the engagement, you can see that on your screen here. Everything that we do, everything that all professionals do is defined by the contract. In accounting, a bookkeeper is not an auditor. An architect is not an engineer. Dentists aren't plastic surgeons, right? Clients engage us, professionals, to perform specific, defined tasks. And we're judged based on what we were hired to do. So it's essential that we obtain clear engagement terms. And it's important that we set and manage expectations. The more specific, the better. After a lawsuit, after everything hits the fan, we look to the engagement letter to define what the roles were of attorney and of client. This is the contract. So the scope of that contract is critical. From there, it gets a little bit more complicated, but you need to be thinking outside the contract itself by confirming that the scope in your engagement is consistent with what you've done. What about your time records? Do the invoices match the client's expectations? Are you billing for the work that you actually agreed to perform, or something more? Do the task descriptions conflict with the engagement letter? If so, that's a problem. I'm seeing this more and more. Look at your website. The services that you've identified in your website, what representations are you making? Are you saying that you're an expert in a particular field? Rest assured that will be in a complaint if you do. What are you advertising? The plaintiff has checked your website and will use it against you if she can. And you should be thinking ahead. Think of these issues now, because once a lawsuit pops up, we're certainly going to be talking about the scope of the engagement. Okay, next slide is the specifics of an engagement letter. And Matt, I think you're going to touch on that.
Yeah, I mean, that's okay. Yeah, that. Yeah, I mean, that's so the most important thing. I mean, the slide that's there now, like, that's all helpful, but the biggest points that we want to get across to you are this, and again, because I know we want to move this along, is do the very best you can to define who you are representing and for what. That's, make it clear what you're doing and make it clear what you're not doing. Same thing, if you review a potential matter and you decide not to accept that representation, send a letter ASAP telling them that. Also, if during the representation of a client who you are representing that it seems to you like someone else is relying on you for advice, call a timeout and set them straight. Where do we see this happen? Well, in the trust estates area of practice for sure, where, you've got family members contacting you and wanting to engage you in conversations about things. You're not their lawyer. You may have some duties to them, but also like transactional matters, especially if one side is not represented, where we've seen this is you're hired by somebody to draft some documents, hired by your client, and that client is then dealing with somebody else who's not represented, in a business deal, and then something goes wrong, and that other party says, I was relying on you to be my lawyer, and you're like, no, I wasn't your lawyer. That is, make it clear to people that are sort of surrounding the representation that you're not representing them, and that they need to get their own lawyer. One thing I'll also say is that on the importance of engagement letters, insurance carriers recognize the importance and even reward the use of engagement letters. What we're seeing increasingly are that, let's say you've got a policy with a certain deductible and you get sued, and maybe you've got like a $5,000 deductible on that policy. Well, if you have an engagement letter that you can point to related to that claim, a lot of times we're seeing more that insurance carriers are giving you a break on the deductible, because they're saying, all right, well, at least you tried to do the right thing here. You tried to do that. So let's see. Why don't we skip ahead? The sample letters are there. Let's pass by that. Let's touch briefly on conflicts of interest. Again, it's a big driver, especially in claims for large firms. What I would say is review the RPCs on conflicts of interest, be familiar with them, know what they are, and consult them if you ever have any question in your own head about something. And if it's unclear, look at the comments to the RPCs, because the comments oftentimes can give examples. We'll give examples about like different situations, whether or not it's a conflict, whether it isn't. Where do we see them arise? Again, in large law firm claims, plaintiffs' lawyers can find current or past relationships there that they can use to create the appearance of a conflict, pretty easily. We also see them again in the trust and estates setting, where a lawyer is trying to wear too many hats, or in dealing with an unrepresented party. Again, these same principles apply. Make it clear to people that you're not representing somebody, because if you make that clear, well, then there's no conflict. So a lot of times, like the alleged conflict of interest and sort of the person you're not representing suing you, those things go hand in hand, because you're not representing them and you know that, but that person doesn't know that, and so they're saying you got a conflict of interest. So again, it's just making clear to people that you're not representing them, and for the people that you are representing, make clear to them what you're doing. Those are really the biggest takeaways on the topic of conflicts of interest. Let's see, Seth, I'll keep going here. Insurance considerations. We touched on these briefly as well, but look at your malpractice policy. Look at it. What's your limit? How do you have enough limit? Talk to your broker about it. Look at the kinds of matters that you're handling. Look at the size of the deals or size of the matters that you're handling. If you're handling, if you're involved in deals that routinely are upwards of $1 million, or even sometimes upwards of $1 million, I would suggest that maybe a $100,000 limit isn't sufficient for you. And we see that. So take a look at that. Look at whether, again, I mentioned this earlier, look at whether defense costs erode your limit of liability. If you get sued and we get hired to defend you, every dollar that gets paid to us, is that going to reduce your limit? There are different, you can ask for defense to be outside the limits, or you can ask for, or it can be inside the limits. Either way. One important point too I want to mention, because we've seen this. Be aware that malpractice policies are called claims made and reported policies. They don't operate the same way as an auto policy. Let me explain. If you were in an auto accident a year and a half ago and you get sued for it today, the policy you had on your auto accident, which is an occurrence policy, the policy that you had in place a year and a half ago when the accident happened, that's going to defend you. Malpractice policies don't work the same way. If you get hit with a claim, or you're advised that a claim is forthcoming, you have to tell your malpractice carrier right away. Because if you don't, and if you wait on it, maybe a year later, the carrier can say, you didn't report this to us on a timely basis, and we're not going to cover it. So, and we've seen this happen with lawyers, that they just don't understand the way claims made and reported policies work. And I can guarantee you that, virtually guarantee you, that every malpractice policy that's out there now is a claims made and reported policy. So look at the policy, understand how it works, understand when you need to tell the carrier that you know, I'm not saying that like if you whatever, like some small mistake that you feel like you can correct, you don't need to tell them about every single thing. But if you're told that something's coming, you got to let them know. All right. I think one last thing here. This is what I say: avoid the problem client. You know, this is and it's kind of I say, you know, use your spidey sense. You know, the best thing you can do to outside of all the things that we've told you to avoid malpractice claims, learn how to spot somebody who you think is going to be a problem. What are the markers there? You know, if they have a current lawyer, they want to leave and come, you know, have you represent them, or if you're maybe the third lawyer in a chain, you know, that's a red flag. Somebody who's never satisfied, thinks that, you know, you should be happy for their business, has unreasonable expectations, doesn't pay your bills, unresponsive but demanding, always in a rush. You know, those are red flags of people that could be a problem later on. And then, you know, the unpaid legal fees, Seth touched on this earlier, and actually I saw one of the comments there to stop dumping on collection lawyers. You know, we're not saying, I agree that lawyers deserve to get paid for their services. I do, but you need to be careful about it. You need to evaluate when you might be suing a client to get those fees back, because if it is a problem client and if the fees maybe aren't that much, you know, think about whether or not you really want to pursue it or just absorb the loss. I mean, if it's a lot of money you're owed, I mean, we're not going to tell you not to do that, but just be aware that, you know, you know, evaluate it, look at it, and I would say expect the possibility of a malpractice claim in response, if for no other reason that they're going to try to get out of paying you the fee. So that's the thing there. I think we can probably skip over the negative online reviews here, and takeaways and best practices. Practice what you know. Avoid dabbling. Avoid the problem client. You know, be careful with conflicts. Utilize engagement and disengagement letters. Be familiar with your insurance, please, for all the reasons that I mentioned, because that's what's there to protect you if something does go wrong. So understand what you're covered for and what you're not covered for. Seth?
Yeah, thanks, Matt. I'll just put a bow on this, as I see that we only have a couple minutes left. But what we do for a living is hard. Practicing law is difficult. We work to build careers. We work to build our book. We work to develop a reputation, especially. Don't risk it all by, you know, I can't help but use sports analogies. You want to get beaten by your best pitch, right? So don't go outside your comfort zone. All right. Thank you for listening. Thank you for spending an hour with us. Matt, thank you for spending your milestone birthday with us. I don't know that there's anywhere else you'd rather be. Kate, if there's time, do you want to cover a couple questions?
We're happy to stay beyond the hour, too, if anybody wants to, not too obligated to. We're happy to stick around.
Here's the first question. How do you define an attorney that is of counsel? What is the difference between an of counsel attorney and a part-time associate?
That sounds, and before I answer that, you know, I'll also say, look, I mean, Seth and I are both, I have to be careful what I'm saying here, but Seth and I are both pretty easily found on the internet. So I know, I mean, so I'll speak for myself. If you do have a question that we're not going to get to here, and you know, and you want to follow up, you know, feel free to shoot me an email, and I'll try to respond to you. Again, it's not legal advice. It's not going to be creating an attorney-client relationship, but certainly happy to, you know, to answer any questions through email if you have it. But that sounds to me like an insurance question. For instance, you know, I mean, small firms are typically rated by insurance carriers on the amount of lawyers that they have, whether they're full-time, part-time, of counsel, you know, and the premium associated with those lawyers will generally vary depending on what the status is. So I would say that the best place to start there would be actually asking your insurance broker or the carrier how they're defining it, because they'll have underwriting guidelines as to how it's defined. How you want to, and also look at your look at your state's ethics rules. See what guidance your state has on that, because I think states are probably gonna vary as to how and under what circumstances you can hold out a lawyer as of counsel with your firm, what that relationship is. So I would say that those are the two best. That's going to vary by insurance carrier. It's going to vary by state. So I would say to consult those two places.
Okay, great. Thanks, Matt. Next question. In doing wills and trusts for a wife and husband, can you represent both? Is disclosing conflicts and obtaining a waiver in a retainer agreement sufficient?
I think you can represent both. I don't see any conflict in representing both husband and wife in wills, and we see it all the time. There's probably situations that could arise where there might be one, but generally speaking, I don't think the interests are really going to be adverse to each other. If they're both coming to you, they both want wills, and the wills, while they might relate to each other, like somebody's estate goes to the other, they're both kind of agreeing to that, right? And then they might have different alternative beneficiaries after that, but that would be that can be addressed in each person's will. So I don't see that as being a conflict under a normal situation, typical situation, I should say.
And I'll ask one more question since we're running out of time here. How specific should engagement letters be as to what is being represented?
Yeah, I can jump in on this one. That's a good question. I would urge our listeners to be as specific as you possibly can. The engagement letter serves as bookends to define the relationship. The broader it is, the more that attorney is expected to accomplish. The narrower it is, the easier it is to identify what you're hired to do. So when reasonable and when appropriate, I would be as specific as you possibly can.
Okay, great. Thanks, Seth. At this point, we're out of time for further questions. That concludes today's event. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Seth and Matt. Thanks so much. Have a great day.
Thank you.